Hello and welcome everyone to week 6 of MPA 545, Conflict Resolution and Labor Negotiation. My name is Greg Zarko and this is my presentation for the week. Okay, so this week we will be discussing 4 different types of alternate dispute resolutions, otherwise known as ADRs, and I will locate a journal for each one of them, and then I will locate one news story, or at a minimum one news story, to talk about one of these ADRs. Okay, so the first ADR that we're going to discuss is the early neutral evaluation. Our textbook says that some cases of conflict that pertain to personal injury or employee discrimination, early neutral evaluation can be used, and this is where a third party comes in and gives their advice. Or, in other words, an E&E uses an independent expert to assess the merits of the case in the hope of providing the parties with an objective appraisal or a reality check, concerning their prospects of success. And although an E&E is not binding upon the parties like mediation, unlike mediation where a mediator is not supposed to provide an assessment of the parties' respective positions, the parties can draw on the knowledge and experience of the expert to better understand the merits of the claim. And so the article that I found is, I'm sorry, is is titled "Is Early Neutral Evaluation the Start of a New Way of Resolving Probate Disputes?" And a probate is a legal process that administers the distribution of a deceased person's assets. So in this case, in this article that I read, it talks about these two adult children who are in dispute with their late father's ex-wife, and an E&E was used to come to an agreement to separate the assets of the deceased person. And it actually was quite successful. Both parties left feeling pleased with what they received, and the courts decided that it was a better outcome because they saved a lot of trouble and money. So the article really is questioning if E&Es can start being used in this kind of conflict. Um, and in this case, at least, it worked. The second ADR that we will be discussing is the Dispute Review Board, or the DRB. And DRBs are mainly used for large civil infrastructure projects that involve high risk and high liability contracts. Um, and a DRB is composed of a panel of experts that is led by an ADR professional, and they've all been chosen by both the clients and the contractors. As the project develops, the board issues non-binding rulings on contract issues and other conflicts that may arise. Um, the DRB meets quarterly for a full day session during which they receive status updates, conditions of the site, and progress of the project, and the fulfillment of the contract obligations. And really, their goal is to prevent unreasonable delays and to manage disputes as they emerge. And the article that I found, um, the dispute, by Genton, called the Dispute Review Board Wishful Thinking or Reality, uh, does a good job of comparing and contrasting the the merits of having a DRB. Um, how a DRB means that the parties will have to deal in good faith and should be ready to reconsider their positions, if the DRB's at the DRB's recommendation. Um, and it talks about how life without a DRB, how it could be very costly and time consuming, and there are many things that could affect uh, a project, such as the market changing or the cost of materials rising. And so DRB really is a good complementary requirement to litigation, as they put it. Um, So what was it similar? The article talked about how, while yes, these DRBs are for large civil infrastructures, it could also be used for small projects because it can be run at any time. That it really helps the flow of the project. It also expanded that because if you can use it for the large projects, then you can also use it for the smaller ones. The third ADR that we will be discussing is the mini trial. And mini trials were initially called information exchange. Um, and that's because they enable people, agencies, organizations that are in dispute to engage in non-binding, voluntary, and in a structured hearing to resolve disputes over issues such as product liability, antitrust, contracts, patent infringement, and employee grievances. And although a mini trial is more expensive than mediation or arbitration, it is less expensive than litigation. And another or a good thing about a mini trial is that it established a time limit for different phases of the case. Um, and one of the videos that we saw explained how during the hearing phase, each party is given approximately 2 hours to present their case however they see fit. Um, and I thought that was very interesting. So the article that I read was Edelman, and it's a statement of Lester Edelman, who's the chief counsel for the U.S. Army Corps of Engineers, and in it he is vouching and arguing for ADRs and how successful they have been in helping the Corps of Engineers in litigation save time and money in the overall scheme of things by being able to continue working on projects that they've signed contracts with um, while while reducing the amount of time they spent in litigation or not working. Um, and so I was able to find a news story about the first time the U.S. Army Corps of Engineers use an ADR, use a mini trial, and it was a settlement that they ended up reaching with I'm sorry, Morrison and Knudsen Company, and there was a initially they entered to a contract where the Morrison Knudsen Company had agreed to excavate about 11 miles um, in Mississippi, and so they had signed the contract. And eventually, when they got down the road, they realized that the soil was different than what they originally had inspected at the starting point, and so they needed to get different equipment. They needed to dig differently, and so this ended up increasing the price of the initial bid. Um, and so a mini trial was used for this conflict, and Morrison Knudsen, it did end up getting a $45 million settlement from the Army Corps of Engineers. Um, so, so what I found interesting was how the articles expanded on the mini trials. How even the 45 million does sound like a lot of money, they see the bigger picture that they could have spent a lot more money and done a lot less work and been in a worse spot if not for the mini trial. Okay, so the last ADR that we're going to be speaking about is a summary jury trial, or the SJT. And this involves a non-binding trial that occurs prior to actually going to full trial. Um, and this is a format that enables people that are in dispute or companies that are in dispute and lawyers to see how a potential jury might react to their arguments and case how the presiding judge might rule on their issues. And so the article that I found was by Lambros, and it just gives a summary on the jury trial. And basically what they're saying is that in the 1980s, with the Speedy Trial Act that passed, it really caused a backlog on the civil trial dockets, and because of the constitutional and statutory priority given to criminal cases, all the dockets were backlogged. Um, and the speedy trials are not intended to replace traditional trials by juries. They're just there to provide settlement opportunities and to gauge how a jury or a case might turn out. And the article states that this is a good tool for the lawyers to have in order to better prepare themselves to whether prepare for jury or prepare for trial, or to give advice to their clients on settling a case. That concludes my presentation for the week. Thank you very much for listening. I look forward to listening to yours. Have a good week and God bless.